And thus much may suffice for persons of inferior condition, who have neither time nor capacity to enlarge their views beyond that contracted sphere in which they are appointed to move. But those on whom nature and fortune have bestowed more abilities and greater leisure cannot be so easily excused. These advantages are given them, not for the benefit of themselves only, but also of the public, and yet they cannot, in any scene of life, discharge properly their duty either to the public or themselves, without some degree of knowledge in the laws. To evince this the more clearly, it may not be amiss to descend to a few particulars. Let us therefore begin with our gentlemen of independent estates and fortune, the most useful as well as considerable body of men in the nation, whom even to suppose ignorant in this branch of learning is treated by Mr. Locke as a strange absurdity. It is their landed property, with its long and voluminous train of descents and conveniences, settlements, entails, and encumbrances, that forms the most intricate and most extensive object of legal knowledge. The thorough comprehension of these, in all their minute distinctions, is perhaps too laborious a talk for any but a lawyer of profession. Yet still the understanding of a few leading principles relating to estates and conveyancing may form some check and guard upon a gentleman's inferior agents, and preserve him at least from very gross and notorious imposition. Again, the policy of all laws has made some forms necessary in the wording of last wills and testaments, and more with regard to their attestation, and ignorance of these must always be of dangerous consequence to such as by choice or necessity compile their own testaments without any technical assistance. Those who have attended the courts of justice are the best witnesses of the constitution and distresses that are hereby occasioned in families, and of the difficulties that arise in discerning the true meaning of the testator, or sometimes in discovering any meaning at all, so that in the end his estate may often be vested quite contrary to these his enigmatical intentions, because perhaps he has omitted one or two formal words, which are necessary to ascertain the sense with indisputable legal precision, or has executed his will in the presence of fewer witnesses than the law requires. But to proceed from private concerns to those of a more public consideration. All gentlemen of fortune are, in consequence of their property, liable to be called upon to establish the rights, to estimate the injuries, to weigh the accusations, and sometimes to dispose of the lives of their fellow subjects, by serving upon juries. In this situation they are frequently to decide, and that upon their oaths, questions of nice importance, in the solution of which some legal skill is requisite, especially where the law and the fact, as it often happens, are intimately blended together, and the general incapacity, even of our best juries, to do this with any tolerable propriety, has greatly debased their authority, and has unavoidably thrown more power into the hands of the judges to direct, control, and even reverse their verdicts, than perhaps the Constitution intended. But it is not as a juror only that the English gentleman is called upon to determine questions of right, and distribute justice to his fellow subject. It is principally with this order of men that the commission of the peace is filled. And here a very ample field is opened for a gentleman to exert his talents, by maintaining good order in his neighborhood, by punishing the dissolute and idle, by protecting the peaceable and industrious, and, above all, by healing petty differences and preventing vexatious prosecutions. But, in order to attain these desirable ends, it is necessary that the magistrate should understand his business, and have not only the will, but the power also, under which must be included the knowledge of administering legal and effectual justice. Else, when he has mistaken his authority through passion, through ignorance, or absurdity, he will be the object of contempt from his inferiors, and of censure from those to whom he is accountable for his conduct. Yet further, most gentlemen of considerable property, at some period or other in their lives, are ambitious of representing their country in Parliament, and those who are ambitious of receiving so high a trust would also do well to remember its nature and importance. They are not thus honorably distinguished from the rest of their fellow subjects, merely that they may privilege their persons, their estates, or their domestics, that they may list under party banners, may grant or withhold supplies, may vote with or vote against a popular or unpopular administration, but upon considerations far more interesting and important. They are the guardians of the English Constitution, the makers, repealers, and interpreters of the English laws, delegated to watch, to check, and to avert every dangerous innovation, to propose, to adopt, and to cherish any solid and well-weighted improvement, bound by every tie of nature, of honor, and of religion, to transmit that Constitution and those laws to their posterity, amended if possible, at least without any derogation. And how unbecoming must it appear in a member of the legislature to vote for a new law, who is utterly ignorant of the old? What kind of interpretation can he be enabled to give, who is a stranger to the text upon which he comments? Indeed, it is really amazing that there should be no other state of life, no other occupation, art, or science, in which some method of instruction is not looked upon as requisite, except only the science of legislation. The noblest and most difficult of any apprenticeships are held necessary to almost every art, commercial or mechanical. A long course of reading and study must form the divine, the physician, and the practical professor of the laws, but every man of superior fortune thinks himself born a legislator. Yet Tully was of a different opinion. "It is necessary," says he, "for a senator to be thoroughly acquainted with the Constitution, and this, he declares, is a knowledge of the most extensive nature, a matter of science, of diligence, of reflections, without which no senator can possibly be fit for his office. The mischiefs that have arisen to the public from inconsiderate alterations in our laws are too obvious to be called in question, and how far they have been owing to the defective education of our senators is a point well worthy the public attention. The common law of England has fared like other venerable edifices of antiquity, which rash and unexperienced workmen have ventured to new dress and refine, with all the rage of modern improvement. Hence frequently its symmetry has been destroyed, its proportions distorted, and its majestic simplicity exchanged for specious embellishments and fantastic novelties. For, to say the truth, almost all the perplexed questions, almost all the niceties, the intricacies, and delays, which have sometimes disgraced the English as well as other courts of justice, owe their original not to the common law itself, but to innovations that have been made in it by acts of Parliament, overladen, as Sir Edward Coke expresses it, with provisions and additions, and many times on a sudden, penned or corrected by men of none or very little judgment in law.